and to the republic which stands, one nation, under God, indivisible, with liberty and justice for all.
Good evening, everyone. Thanks for coming. First item of business is approval of the February 19th study session minutes.
Motion to approve.
Second. Any discussion? All in favor?
Aye.
Any opposed? Approval of the bills list. You'll notice on there that there is a bit of an explanation on the right-hand side of the page.
I assume the development, they pay for that. The developer pays for the development review.
Yeah, that cost to pass on to them.
Yep.
It's public approval process. That's what I think.
Is there a motion to approve?
Approve.
Is there a second? Second. Any discussion? All in favor?
Aye.
Any opposed? Accept public comments? Yes, ma'am.
Phyllis Van Dyke, 208 South Central. I'd like to address the amended rental agreement on City Hall. I've been on the festival committee for over 15 years. I've devoted untold hours to community betterment, to community service, to community events. I find it disrespectful and frankly, ungrateful that the committee members have lost the one perk that we had, which was free use of City Hall. I've rented other venues. It's not that I wouldn't rent a venue if I had an event that required it. I just find it really insulting that this group decided that all of those hours that we have put in without compensation have been just erased. That was our one perk. I would ask you to reconsider because it really is insulting. Thank you.
Will I be able to speak on the agenda item, or do you want me to speak now? Go now? As everyone's aware, with what Phyllis just said, removing the free rental for a board member, an employee, or an elected official, now it's been changed to just a elected official or an employee. So that targeted someone in particular that I'm not happy about, which was me. I do feel that it's taken a whole lot away from a whole lot of people that work on boards and do a lot for this town. And now you're wanting to take that away from those people. That's very unfair, not being reasonable or fair with your community. I think that was a horrible call. To move on to the fact of the alcohol in the multi-use facility, I'd really like for you all to consider doing that. I've had 3 of the aldermen down along with the mayor. I've invited everyone, but 3 of the aldermen and the mayor did come down. The aldermen, whenever I met with them individually, they were very impressed how it was ran, what went on. And whenever the mayor came down with his consent for saying what I'm saying next, we stood outside that window and he said, "Wow, I'm surprised. This is not what I expected." It's very organized. It's not a beer brawl. It's not coming in here and getting drunk and getting liquored up. These guys come down here to play for money. We've got $2,000 in the boards, computer system, so organized. You can look up the stats right now online. You can tell what all these people's stats are against people across the whole country, mainly the Midwest, but it goes all over the country. It's just a super well-organized event. It helps our downtown businesses. Every business down here has said that it helps them. They don't want to see it go away. So if we can reconsider the one thing on the alcohol, I'll pay the money to rent the place. that's fine, I understand, we can go with that, but I will say that the ladies in the office said, since we've started doing this, they have not cleaned the courtroom or the bathrooms in the last 10, 11 weeks we've been doing it. Because we clean this place up every single week. The chairs are a little bit messed up now.
30 seconds.
We had court down here Tuesday, we haven't had cornhole, so our guys did get clean the place up. So they do a good thing with it. And again, I'm really thankful for the ones that did come down. Having you come down, Daryl, you got to see what was going on. It was just a really cool event, you know. It brings a lot of people down here. Wednesday night, there's not a parking spot. It's packed from front to back with people. And it's a really good event, and I would like to have some consideration for us to continue doing it. And I'm open to any questions. Thank you.
Thank you. Next up, old business, discussion, consideration, of possible action regarding the food truck ordinance. You saw the amendment in your packet.
It looks like pretty good from what we came up with that night, except for we had a problem with where it says food trucks may vend in these approved vending districts a total of 12 times per year. We had discussed people wondering if that's per vendor, and that's not per vendor. That's 12 times per year.
Correct, yeah.
So, but we had people asking, is that per vendor?
Oh, the way,
Yeah, for business.
Yeah.
I see. Okay, the way that I have it written now is that like the vending district gets 12 times a
Okay.
year, irregardless of.
So we just have to explain it to them then, okay?
Yeah, it would be 12 times total. It wouldn't, it's not like this business gets 12 or that business gets 12 or this school gets 12 and the church gets 12. It's 12 total in those
Right.
vending districts.
And then the other thing is the last one, on the 20th to the 4th. Wouldn't that just come under the private events? Did it have to be put in there like that, or could it just, I mean, because it is a private, it's just for themselves. Wouldn't that come under the, up here where it talks about private events?
It would.
But isn't that also open to the public?
Yeah, if they're
That's-
selling.
I think it's a public event, but on a private
Yeah,
property.
versus a wedding or
Yeah.
birthday.
It's not a
party, it
closed
has to be on
event to
public
the
event.
cities. I think that's.
I got you.
That's the plan, yeah. The private parties or private events. I meant parties as like literally a party or a private event at an event where someone cannot walk off the street and go vend from the food truck. It would have to be someone who was invited, like a wedding reception, as I understand.
Well, I just kind of took it, they were kind of invited when they're coming for fireworks. Okay, I get you, yeah.
Can I ask a couple questions too? Off his question that it's only 12 times at the parking lot up here, the vending district.
Correct, that's the way I have it written.
We don't really have any control over who goes up there, correct? They don't have to have a permit to go sit there.
They need to have a food truck license.
License, but once they got a license, they can go sit there 12 days in a row, and then it's open.
Well, I suppose someone could do that, yes. The expectation would be shared with them when they're filling out their food truck vendor that it's 12 times per year in that area. But I see what you're saying. Someone could try to take advantage of this language and say.
Or, yeah, at first I thought they could be there all year long, but it does say 12 days. But yes, who could, but then, yeah, if some vendor sits out there for 3 days at the beginning of the year, that means essentially the committees or whatever only have 9 more days. I mean, they can go get a special permit, but.
And maybe that's, we were thinking you can invite them 12 times per year, and so, I don't know how you.
But once we create this, there's no I mean, they have to have the food vendor's license, but they don't have to have a permit to sit down
Do we change 12 times per year to 12 events per year and then put with the event not to exceed 24 hours?
there. Well, what if it was just 12 per person? 12 per truck? I mean, yes,
Then
that
we
gets-
might as well just open it up and say there's no.
Well, but then nobody can sit there for a month. That's when I first saw this, I'm like, well, why wouldn't somebody just sit down there for 30 days? Park their truck down there every day.
Well, I get what you're saying, but the night that we drew this up, that's not what we agreed to.
I guess, Michael, when you say sit down there, you mean in this parking lot?
Yeah.
But even that's, I think they need a permit for that parking lot.
No, because it becomes in the zone. Once it's in the zone, they can go
Change
there
it to a zone. Yeah.
So that parking lot is public property because it's owned by the city, but it's owned by the city. It's not like a sidewalk public property, which is really just right of way that you have on top of someone else's property. So the city can limit the time, place, and frequency that a food truck wants to vend there. Their license is not just a license to come to Buckner whenever they want and vend wherever they want. Since it's city-owned property, the city can direct them when they cannot use that property. I mean, I can add more language, but the problem is you start adding more language, you start possibly creating.
Correct, I think we've already done that, in my opinion. But
Okay.
yeah. But yeah, I mean, they have hours that they could be there, so we'd have to shut up every night at 12 a.m. and they can't open again till. But that's what I wondered is, the first person that goes down there wins.
Well, that brings up another thing. If
But the night-
it's
the
12
night-
times a year, is it just one truck or however many trucks you can set in that lot?
We just discussed, well, I assume it's per event,
You'll be as many-
you can put as many trucks out there for that event that you want for that night. But the way we put it out was for occasions, not just for setting food trucks out there. And if that's what we were gonna do, I wouldn't even vote for that. That's not what we,
Right.
that's not what we set up that night. Spent all that time talking. And Tammy agreed to this. You know, and this is what she set up on her paper for me, and I went and talked to the other food people, and that's what we agreed upon. If we do this, then we're opening everything right back up.
Sure. So this was drafted with the idea that these food trucks would essentially be invited to the city of Buckner.
Yes.
I work downtown Kansas City, Missouri, and there is an issue where food trucks will flock there between 11 and 1 p.m. just because you've got 20,000 captive people who need lunch. You know,
Right.
there's a huge market there. Here, less so, I believe. I do not believe there are food trucks coming to town hoping to hit it big. And so the idea is that this would be on an invitation basis. I agree with you, Alderman Leeds. You found a weakness here that someone could, if they wanted to be exploitative, come to town and say, I get 12 times, I'm going to be here for 12 straight days. I mean, this would technically legally allow them to do that. We would obviously stop that at some point. I mean, city owns that parking lot. The city's not. That's not what this ordinance means. It'd be explained. But this was drafted with the idea that these would be events like Sip and Stroll Third Thursdays where they're going to be invited and say, hey, look, you've got 100 to 200 people that are going to be downtown. Please come on out, kind of thing. What I would recommend is these are good ideas that are brought up. I wouldn't recommend making changes on the fly. If you want, you can send me back with it. But I think we should give this language some chance to breathe and see how it works in practice. If we have someone who is trying to take advantage of this or think, because we also put City Park in here too, as one of the vending districts where now food trucks can go. So theoretically, someone could be here in the city within 24 straight days. They could go 12 here and down there and they wouldn't violate it. But unless or until someone's taking advantage of it, I don't know that we need, small government's the best kind. I don't know that we need more language in here, is what I'd recommend.
And the 12 times is just the Hudson district, right? The Fort Park would be different. And I say that because the school is wanting to do the thing with the students again in the summer.
Yeah.
And I wouldn't want to get where we couldn't feed the kids after 2 weeks.
Oh, certainly, yeah. So this 12 times is limited for each of those districts. So there is, technically, the way I've written it here, the city park also has a limit of 12 events per year where food trucks can be present.
But there's latitude for the mayor
Yeah.
to waive that if
Which is maybe
that's every.
There is, yes. And
So
like
the
this-
school, we could tell the school,
Absolutely.
you're giving free lunches, keep time.
Yes, yeah.
When there's no money exchanged in that, it's just.
Right. The waivers would become an issue if you start giving them to for-profit businesses and then you don't give it to another for-profit, then it's why did you give to one and not the other? But a non-profit or someone where there's no exchange of money like the school, that is like the prototypical case for why you would waive the 12 limit or as it count as one towards the limit.
And just for clarification, the park closes, so they'd have to leave at 11 o'clock every night.
Oh, yes.
Where the parking lot, I assume there's no restriction, they can park there all night if they want, right? And I assume there's no.
I don't know if there are any parking
No.
restrictions on the park.
Well, the only parking restriction is weight limitation, but that's for big tractor trailers, we never have big tractor
Yeah,
trailers.
but that's, I think again, moot, but I just wanted, and then the other question, the 245070, the provisions of this section shall not apply.
Yeah.
What does this section mean?
Section is the entire section, 27245.070, and what follows in this chapter is the way I usually write that. I mean,
What
there's-
follows,
Yes,
okay.
there's a Latin phrase I can put behind it, but honestly,
Okay,
it just
that's-
needlessly legalese it up. So
That's fine with me.
the way it's interpreted is that section and all following
Yeah, I agree. We just kind of leave it as is, and then we can play it by ear or adjust as needed as we go forward. My thoughts.
Is there a motion to approve?
I'll make a motion to approve.
I'll second it.
Any additional discussion?
I have one question. I think on the new form, it should have a revised date on there because we've had at least one, a wrong form distributed. So if we have the effective date as of March 2nd or whatever, I think that ought to be on the form. So
Oh, I see.
that way it would identify the most current form.
You're talking about for this ordinance?
Yes, as far as the document.
Yes. Okay, we can reflect that that doesn't require a motion to amend. I do have a point of order though, Mayor. Has the title of this been read?
That was my question, as I said that, I didn't know because it's.
No, I just had a discussion, I figured we'd be back at
Okay.
the next one.
So we need to move to
So-
suspend the rules and.
Yeah, I'll read it once, and then you'll call for the motion to suspend the rules, and then I'll read it a second time, and then we proceed with the vote. So I'll start now by reading it by title only for the first time into the record. An ordinance amending section 245.070, vending and vending districts only, and section 245.080, vending districts, vending prohibited in certain areas of the City of Buckner Municipal Code.
Okay, now we take a motion to suspend the rule.
Those moves.
Second. All in favor?
Aye.
Any opposed?
Opposed?
Second reading, an ordinance amending section 245.070, vending and vending districts only, and section 245.080, vending districts, vending prohibited in certain areas of the City of Buckner Municipal Code.
Move to approve.
Alderman Jones.
Aye.
Alderman Clyde.
Aye.
Alderman Ross.
Aye.
Alderman Lockhart. Alderman Leeds.
Aye.
Alderman Lewis.
Aye.
Very good, thank you, folks. Thank you, council. Next item of discussion, consideration, possible action regarding the Millwood, City Hall. You got the current language there for you.
Just for clarification, this board has not changed anything, right? This,
Correct.
the way it reads now was approved at some point
Right.
in the past.
Yeah, June
I
20th.
appreciate that.
2020.
Yeah, we haven't changed anything.
Yeah, that's what, and that's fine. Yeah,
That was gonna be my question if I missed something.
Yeah.
last time.
No, it
that's the way it's been, the way the permit has read for,
says June 2020.
yeah, forever.
No, it was changed originally from the original.
We just in theory didn't follow the policy.
Yeah, somehow they get communicated the cases where she wasn't using the latest version. She had the old agreement.
So, Joe sent out an email to all the towns. He got back quite a few responses, like 19 responses on do you rent out your courtroom for events and do you serve out and do you allow alcohol? And so, probably 6 or 7 just say they don't rent it out. A lot of them have their own community centers. There's 2 of them, 2 or 3 that allowed alcohol in here. And so, my judgment on this depends on what you got to say.
Oh.
I mean, because if there's any scenario that we could be held responsible for this, then my vote's a no.
Sure. So let me start by saying Missouri is a really rare state. It's the state that Anheuser-Busch helped build. So there is no statewide law that says you can't drink on a city's property. I mean, Kansas has that law, teetotaling Kansas, Iowa, Nebraska, but Missouri does not. So there are cities that can't allow alcohol on their premises. It's really a risk-reward factor for cities to make. The number one thing, in my opinion, doesn't matter as much as our insurance companies opinion matters. So I guarantee that our policy was written with our ordinances in mind, where it's in our ordinances 2 places. One is a public offense, which means chief can arrest you for it, and one of them is just a general prohibition that you're not allowed to drink alcohol or have an open container on city-owned public property. That's 2 places in our code. We can make those changes. There's nothing in Missouri law that says you
And scenario that the city could be liable for.
Yeah, sure, and absolutely. I mean, absolutely. Arrowhead parking lot, there is an average of 1 homicide a year at Chiefs games, 1 punch homicides, and they absolutely pay more for insurance. They absolutely pay out more because they explicitly allow tailgating at the Arrowhead parking lot. And I'm not equating any event you hold here to those huge crowds at Arrowhead. But the general fact of the matter is, the Mike's got this, the billboard plaintiff's attorneys would absolutely make hay of the fact that the city of Buckner allows alcohol on its premises if, for example, there was a fight at one of these events and someone were to be killed. That's worst case scenario, right? In a wrongful death lawsuit, not only would the person who killed the other person be a defendant, the city of Buckner absolutely would be a defendant. And I'll be honest with you, the city of Buckner would be a defendant regardless of whether or not we allowed alcohol, but the fact that we allowed alcohol would absolutely be an aggravating factor. It would be used against the city. It would be told to a jury of your peers, and the jury of your peers could draw the consequences of, well, the city of Buckner allowed that, so they allowed that element. Whether that's fair or not, I don't know, but as I'm sitting here, I've sat on juries, I've been a part of jury trials, I know how plaintiffs' lawyers are. They would absolutely try to hang the responsibility on the city, because in a situation like that, the city and the city's insurance policy is the greatest chance of that plaintiff and that plaintiff's lawyer to get paid. So, suing the person who did the 1 punch homicide in the example I'm talking about, that person might not have a whole lot of money, but the city certainly does from a plaintiff lawyer's perspective. And so that's why, generally speaking, we would not recommend as a policy, allowing alcohol on city property. If a city wants to, that's the city's right in Missouri. It doesn't exist in a whole lot of states, but first and foremost, that would take reaching out to our insurance company to see what the difference in our coverage would be with allowing alcohol versus not allowing it as we do now.
And if we didn't allow alcohol, then maybe just leave the statutes the way it is, and it was brought in anyway, not to our knowledge, then what?
It would truly have to be not to our knowledge.
Yeah.
If it were like an open secret, then that same plaintiff's attorney who would make hay of us allowing it would make hay of the fact that it was an open secret and no one really didn't know.
Yeah.
But if we keep the statutes, the code and ordinances the same, then that person bringing it in would just possibly risk a ordinance violation ticket or a misdemeanor ordinance violation criminal charge for having an open container or consuming alcohol on city property. It certainly makes us look better. It certainly helps with liability that we would not allow alcohol on city property. I mean, I hate to be the wet blanket, but as the city attorney, when I'm looking out for public funds and the city's liability, that's a first year law school thing, someone can say.
Well, that's why I specifically asked it the way I did. No, I appreciate that.
Along that same line, someone is consuming alcohol, they drive home, hit somebody, could that be attributed back to the city because they were drinking at this location and had an accident on the way home?
Someone could certainly try, especially if we changed our ordinances to allow alcohol. But what you're talking about is a Dram Shop Act. It was passed in the
Like it
70s
was
or
happening
80s.
at a bar, they know what.
Right,
they know
right.
when to shut it off or whatever.
The difference is we will not be vending alcohol, or at least I hope not. We're not going to be selling alcohol or anything like that. So that whole Dram Shop liability, if someone gets drunk at your establishment and then goes on to hurt someone, that wouldn't really apply to the city since we're not selling or vending alcohol. But again, if alcohol were openly allowed here, an entrepreneuring plaintiff's attorney would certainly still try to sue the city for that.
Okay.
That shuts down our beer garden on city property then for the festival. It's the exact same scenario.
So what I would say is you can issue in your event permits, there is examples from other cities that we can pull where you essentially set aside your own rules for a one-time event or for a community event sort of thing. Respectfully, and this sounds really cool, and I love playing cornhole.
Doesn't release us from being responsible if they drive home and kill somebody, though, so we can't have it there either.
We can, and the difference is how our insurance company would treat it versus a community-wide event that is like a once a year, twice a year, even 3 times a year thing versus an event that's taking place weekly or monthly amongst a group of private citizens who are here to play a game. I think it would be treated differently by our insurance company as opposed to special
But it could
events.
still happen.
Certainly, yeah, anything, it's
It can
America.
still happen one time, special event once a year, so we'll just have to stop it everywhere.
I don't think so. I mean, my review of our codes and what we allow, and the fact that we allow special event permits, and take, for example, the third Thursdays where we're, opening up that as an event, there is a distinction between allowing alcohol being drunk in City Hall versus allowing alcohol to be vended and drunk on city property for special events, festivals. They are treated differently under the law. Our insurance company treats them differently as far as how they would apportion liability. And really the fear is that if we allow alcohol to be drunk here, even though ordinances say they're not, the insurance company would then say they won't cover something that happens. They would say that, this is against the policy that we wrote for you. This isn't the risk profile that we agreed to accept whenever we brought you on, such that we're not going to extend coverage to whatever event happened.
I do have a question on number 8, real quick, kind of off the liquor side. That we could sponsor a group and then they wouldn't have to pay the fee. What's involved? Do we just say, yeah, I sponsor you? Or do I have to show up to that event? Or, it's not really spelled out what that means.
It's not, I can tell you, because this was one of the first things I worked on as a baby lawyer when I joined the firm in June 2020. The idea was that an alderman would be present, and that the alderman being present would, one, keep an eye on whatever club was here, and two, help clean up, make sure the place wasn't trashed. And so if you didn't have the alderman keeping an eye on you, or you didn't have the alderman helping clean up, then the city was going to charge a $50 or $75 fee, essentially just to cover whatever city employee's time would be needed to cover. That was, from my understanding from 5+ years ago, that was the idea behind number 8, was that you had someone who was an elected official, not appointed, which is an important distinction. An elected official here, either sitting here reading a book or being within City Hall and basically being responsible or keeping an eye on the group that's renting City Hall. That was the idea.
Well, past the alcohol question, the rentals, and again, I've been a part of the cornholes. I know I've been to a lot of those fundraiser support. It's awesome and it's fun. It's not. This has nothing to do with you or the cornhole. This, what I'm going to bring up, was something that we had discussed long before that we knew you were going to rent this out. But it brought up a question on when the Kurt sold the chandelier room, that people could rent this cheaper than they could rent that. And so, especially since the new couple just bought that, I just don't think it's fair that we rent this in a competition towards any of the others. It cost us $250 to rent the lodge over there for our.
I guarantee any event center around is more money than a city-owned property.
Well, of course, and I'm not, according to what these 19, and I'll show it to you, that's not the case. There are some, but that's not the case. Most of them are charging $50 to $75 an hour. And I mean, it's right here. It's proof of that.
So take some from the citizens, but that's fine.
I'm not trying to do that.
Comment is ended, so
Yeah.
please direct comments to the board.
Okay. So, I didn't think the city should be in direct competition with our brick and mortar businesses. That's one person's opinion.
Back to number 8. I don't think an elected official or a staff should be treated any different as far as what it costs for rent. I think everybody on the same playing field.
I disagree. I think the board members and the committee members should be getting it for free. 'Cause I agree. I've been on park board for a long time, and I never used it, but I think the benefit, those people are working hard, doing a job that nobody else wants to do. And if, it doesn't cost the city anything to let somebody in.
Incremental utility.
Yeah, no.
I didn't get a break on renting those fields all those years when I was a board member.
Woods Park too, we need, or
I did. Yes, I was.
This is just a policy, so you all can change this at any time. You can do a vote tonight, you can do a vote at the next meeting if you want to amend. This isn't an ordinance, so to speak, so you don't have to put it like in the agenda and require notice of it and have it published a certain amount of time. So I just offer that. This is a policy, it's not in our ordinances.
Well, I think there's a lot to be discussed. I mean, as far as the alcohol is concerned, I think that ought to stop right now. As far as but we already rented this out to him, you know.
But that's already the existing policy.
What's that?
The current ordinance is that we are alcohol free.
Right, which should stop, yeah.
So, I don't know if you'd rather review this, I take this home with you, mark it up,
Yeah.
or not.
What do you think?
Is there an appetite to amend this tonight? Or?
Is it worth reaching out to our insurance just to actually have hard numbers if we allowed it or not? I'm leaning on the side of not allowing in general, but I like to have all the information, what the cost difference is. Is that even worth entertaining or no? Just stay away.
Oh, for the alcohol?
I mean, you have to
From what
take
he
out what's
said-
on our liability insurance.
From what he
That's
said,
probably-
not in my opinion,
Okay.
but I mean,
Picture, I'm just,
Yeah.
throwing it out there.
But yeah, I'll second that if we're willing to say, just get some numbers on
Yeah.
what we're talking about to open up, you know, that we can authorize alcohol at city events.
Check with Mr. Keith. and see what-
That's good. My next meeting.
If
Again, I'm
it comes
leaning
back
to not
to
allowing it.
$18,000, we'd say,
Well-
never mind.
mostly because he made a distinction between events and city hall. So,
Yeah.
But that doesn't, even if the insurance company said that, we're not gonna change your, how much we charge, that doesn't remove our liability.
Correct. The increase in liability over our old ordinance saying no alcohol on city property versus new ordinance saying we explicitly do allow alcohol on city property, that would change our liability. True, the insurance could be an extra $1 a year. It wouldn't change the calculus on how much added liability we'd have under Missouri law. Yeah.
But the insurance is gonna cover that liability. Don't we pay for the maximum amount the government entity can pay?
We do. The problem with yes, insurance will cover it. It won't cover our deductible, which could be $5,000, $10,000, or $15,000 usually for a city. And it wouldn't cover what the change is if someone made a claim because of that.
The next
Or
time.
The next time, right? And what our insurance premiums are the next year or our insurability. You know, it's possible that the insurer that we have now is willing to insure us with alcohol being allowed. But if we get sued and then we gotta go get a new insurer, being out on the market as a city, one of the 2 or 3, as you said, out of 19 that allow it, that can be hard to obtain insurance.
Yep.
So there's a lot that goes
And
into it.
we've just gotten back in, for lack of a better term,
Good
good graces. We had that problem in the past about our insurability, so, yeah, as tight as the budget is, you don't wanna take a, even a $1 hit, but sure, you don't want a $5,000 hit.
Agree.
But, okay, well, hopefully don't mind.
No, I get it wrong.
We'll move on to new business, discussion, consideration, and possible action regarding citywide cleanup day. Joe, you know the.
Yeah, we got the dates, not said, they're available at any time, but May 9th is the date that Sibley is having their drop-off cleanup day. And what they would like to do, AAA would like to do is have both of them going at the same time, that way they can keep running trucks back and forth. So, I mean, but other than that, it's open at any time, but May 9th is what they would prefer us to do.
that's Saturday. What is it? Yeah.
We're gonna have those on calendars up here, they're all 2024.
It is a Saturday.
I'm okay with that.
It's the second Saturday.
Your motion for May 9th?
I'll make a motion for May 9th.
Second.
Any additional discussion with none? All in favor?
Aye.
Any opposed? May 9th it is.
Just real quick, they just charge us for the dumping? Is that
Yeah.
still the case?
Yeah.
They don't charge us for the dumping?
insurance company said back into the graces, and props to the chief and the department so far.
And I would just, for the folks watching on the web, I do want to say thank you to Joe. As you know, he's given us notice that the 23rd, 24th would be his last day. He did graciously offer to stay on for another, through the end of April, as kind of a volunteer member in exchange for keeping his health insurance until his new comes in force. So think about that, 'cause I think we probably would need something around that to a motion to keep him on, but I don't know, counselor.
If he's not being paid, it doesn't, if it's volunteer, then respectfully, it's not spending city funds, so you don't have to vote on that.
We're paying for his health insurance.
No, my insurance, we pay a month in advance, so I'm gonna be here for the whole month of March. So my deductions are coming out of my paycheck for March, which should cover April's payments. So yeah, it's not, no cost to the city,
Okay.
that much.
Yeah, but there's no legal reason that we've gotta like make a motion